The problem is that exchanges and clearinghouses have self-regulatory authorities over FCMs. So in essence, you would be policing yourself.
It doesn't.
You want to use it? Yeah. I don't know if you can use mine.
I'm having some mic problems today, sorry.
Mentioned we use multiple FCMs, to limit our resources and limit our options on who we can use. If one of those goes away, we look at potentially higher hedging costs, less people to do business with.
I think the problem with FIT 21 is it's a way of resolving the jurisdiction between the CFTC and the SEC so that it makes no difference what the SEC thinks, because by the time it weighs in, the tokens are already being traded on the spot market, and the CFTC has to unwind something, and there are hundreds of other tokens.
Ma'am, I don't think that's an accurate description.
Bushel of corn, $3.89. A break-even point is $4.85. Mm-hmm. 3 years ago, we were at over, $8 a bushel.
Our first witness today is Mr. Walter Lukken, who is the President and Chief Executive Officer of the Futures Industry Association. Our next witness is Thomas Sexton, the President and Chief Executive Officer of the National Futures Association. Our third witness will be Mr. Travis Antonsen, who is Senior Vice President for Grain Marketing and Logistics for the Agtegra Cooperative. And our fourth and final witness today is Ms. Alexandra Thornton, who is the Senior Director for Financial Regulation at the Center for American Progress.
The CFTC's enforcement authority has been a closely watched issue during the past several years. Reauthorizing the CFTC gives us the opportunity to closely examine what the Commission is doing and identifying improvements that can be made. Mr. Lukken, back to you. Do you think the Commission's current cross-border authority is effective from a regulatory and enforcement perspective?
I can only speak from my experience at the CFTC, but we were able to work closely with our regulatory authorities overseas to partner with them to make sure that they had the appropriate information. But the important thing is, does the CFTC have direct authority when there is a strong nexus to the United States? And I believe they do, that they have the ability to go after bad behavior overseas when it's a strong nexus to the United States. So I think the CFTC does have appropriate authority.
Now, Mr. Lukken, your testimony raises concerns about conflicts of interest within vertically integrated structures, particularly futures commission merchants owned by exchanges and clearinghouse and embedded in their trading and legal structures. Can you speak more to these concerns and the impact of such structures on our financial systems? And then, Mr. Antonsen, if you could follow up as to whether your members have any concerns.
And we're seeing this more and more, where through the efficiencies of a lot of these crypto platforms, that they're combining both being an exchange, a clearinghouse, and an FCM into one legal entity. The problem is that exchanges and clearinghouses have self-regulatory authorities over FCMs. So in essence, you would be policing yourself and those authorities. We saw some of this, I think, and we raised concerns with the FTX application, where they had a registered, not registered, but a trading arm within their legal structure that were combining the exchange, the clearinghouse, and a trading arm within their legal structure. And that ultimately led to some of the issues we saw with their demise. So we think it's good for the CFTC to take a close look at this to see if there are conflicts of interests that need to be addressed.
Mr. Lukken, in your testimony, you mentioned serving as acting chairman of the CFTC during the last CFTC reauthorization in 2008. You also discussed the increasingly global nature of derivatives markets. Could you please elaborate on how the derivative markets have evolved since that time and address the importance of reauthorizing the CFTC as these markets evolve?
Well, certainly since that time, it's gotten much more global, since I was at the agency. I think the addition of over-the-counter derivatives has added challenges to the CFTC's legal authority. I shouldn't say challenges, but given them...
Sorry, Mr. Lukken, I don't think your mic is on. It is.
You want to use it? Yeah. I don't know if you can use mine.
I'm having some mic problems today, sorry. But no, I think the markets are definitely more global. They're larger, as I mentioned. But we're seeing that the framework has upheld very well. Really, since the Commodity Futures Modernization Act of 2000,
which put in those flexible approaches. The CFTC is allowed to evolve itself with these market trends. So even though we're seeing more global volume, the CFTC has been able to keep pace with those changes. And that's why I think many of us, if not all of us on this dais, are saying that there doesn't need to be a huge overhaul of the Act, that it's actually kept pace with the big global growth.
Mr. Antonsen, in your testimony, you mentioned your concerns regarding the negative potential impacts of Basel III endgame rules may have on the derivatives markets and the end users that rely on them. Could you please share with us some of those negative potential impacts?
I think, when the information first came out, speculation was that we're going to lose many FCMs due to the regulations. From our standpoint, we've seen FCMs get out of the business in the last 5 years. Many of them have. We've seen consolidation in the industry, and that as a user of that, again, I mentioned we use multiple FCMs, to limit our resources and limit our options on who we can use. If one of those goes away, we look at potentially higher hedging costs, less people to do business with.
Very good, thank you. Mr. Lukken, are your members concerned about the impact of these proposals on end users and other market participants?
This is one of our top concerns as an industry. I think rarely does our industry all get on the same page on a topic, but from end users to FCMs to exchanges to clearinghouses, this is going to limit the capacity of people to hedge in our markets. And so, as Travis mentioned, we have seen shrinking number of FCMs, those people that access production agriculture, allow them access to our markets. And if we lose more of those folks, it's gonna make the framework of our system less safe.
When we consider the reauthorization of the Commission and discuss expansion of the authorities, what do you think we need to do to ensure that the CFTC is appropriately funded regulator?
Well, FI supports the full and appropriate funding of the CFTC. When I was acting chairman of the CFTC, it was important for us to talk to the appropriators about why our markets matter. And so I think for us, we do have concerns with user fees in that it would cause less hedging. As I mentioned about capital, it's the same issue that if you're directly taxing hedging capabilities, that's problematic for farmers.
So the user fees then versus the reduction of the $20 million is the trade-off, and you think it's...
No, I think appropriators should find ways to appropriately fund the CFTC and to as they have lots of trade-offs they have to think about because it is taxpayer dollars. But we think the case should be made and is made that the CFTC should be appropriately funded.
Ms. Thornton, you talked about crypto fraud in your comments. How extensive do you describe it today, and what do you think we need to do about it?
I think it's quite substantial, and I think that's something that really needs to be focused on is the use of arbitrage, because these spot markets in tokens, non-crypto asset, in tokens, are actually they have different streams, different data streams. And what that means is that when you buy a token, if you're a consumer and a retail investor and you buy a token, you get offered a price, but you may not know what prices are being offered on the other platforms.
So how do we protect against that fraud?
I'm sorry?
How do we protect against that fraud?
Well, basically, the SEC does that by requiring a national market system. It actually was started in 1975. Congress authorized it in 1975. The idea that the different securities platforms would have to submit data so that a broker would know what the prices are that are being offered for that same security across the different exchanges, and would be able, and then also was given a fiduciary duty of best execution, so that they would have to execute the trade, picking the best price for the customer. But that doesn't exist at all with respect to crypto platforms.
So just get right to it. Can you elaborate on the means to withstand global uncertainties in the commodity markets and the tools for agricultural producers, energy users, and others to deal with the instability that we're currently seeing?
Yeah, I'm sorry. And we see, the days when a producer wants to sell is not the same time that an end user wants to buy. We have huge gaps in volatility, and derivatives get us across that line. The volatility we've seen with weather, our export markets come and go, and being in South Dakota, we export most of our production. We're relying on getting it at least out of the state, and most of that goes to the world market. We get to that point, and yeah, that's our biggest challenge.
In your testimony, you described a court opinion that called into question how customer property is defined by the Commodities Exchange Act, CEA, relative to the U.S. Bankruptcy Code. Could you please share with us some additional background on that issue and why it's potentially problematic for customers?
I certainly can, and this is in the context of FCM bankruptcies, which are rare, thank God. And the importance of the proposal with regard to reauthorization that we are making is that in the Griffin trading case, the one that I am referencing, there was a hole in customer segregated funds caused by a rogue trader many years ago. And obviously the firm did not have sufficient funds to make customers whole at that point in time. And the issue was whether or not customers would step in front of the firm's general creditors in the bankruptcy in order to get whatever funds existed from the company to go into seg funds in order to make customers whole. Very important with regard to customer protections in our view. And the court in that case, the district court, essentially said that the CFTC has a rule that would say, yes, customers can step in front of the general creditors. They called into question the CFTC's legal authority with regard to making that rule in the context of some provisions of the bankruptcy code. So what we're asking for is just that cloud of uncertainty be removed, and extremely important from a customer funds safeguard perspective, we believe.
What agency today has jurisdiction over fraud and manipulation in commodity spot markets?
That's the CFTC, of course.
Okay, so that's the CFTC. What about who has jurisdiction over derivatives for non-securities, those markets?
The CFTC.
The CFTC. When we look at Bitcoin, have there been any courts that have held that Bitcoin is a security?
No, there's just one decision. No.
Has the SEC ever asserted jurisdiction over Bitcoin?
It should have.
Has the SEC ever asserted jurisdiction over Bitcoin?
I don't believe so.
Do you know what volume of the digital assets trading Bitcoin constitutes?
Roughly 90%.
Okay.
But there are hundreds of other tokens.
There are. And does the of those hundreds of other tokens that are not generally considered to be commodities, would FIT 21 continue to place the jurisdiction over those other tokens with the SEC?
I think the problem with FIT 21 is it's a way of resolving the jurisdiction between the CFTC and the SEC so that it makes no difference what the SEC thinks, because by the time it weighs in, the tokens are already being traded on the spot market, and the CFTC has to unwind something, and there are hundreds of other tokens.
Ma'am, I don't think that's an accurate description. And in fact, alleging that the creation of this brand new regime is problematic is just not consistent with the facts on the record. What we know now is by your own answers, the CFTC already has a robust role in this arena. And in fact, in the wake of Dodd-Frank, when they were provided grand new authorities to deal with OTC swaps, there were no failures, there were no problems. I think the broad-based assessment by industry is that they did a magnificent job stepping up and filling that gap because it built on their already existing expertise. That is, they're already doing so much of this. Again, 90% of the volume. I probably would have said 70 or 80, but we can take your assertion at face value. And so I just want to provide greater context. around the robust role the CFTC is already playing in commodity spot markets and in digital assets, the overwhelming majority of digital assets.
Very quickly, I want to ask each member of the panel, do you see yourselves committing to making sure the whistleblower program remains solvent? Could I get a yes, or if there's an equivocation, let me know that.
Yes.
Yes.
It's an important program, but obviously the details would need to be clear before we would have a strong opinion.
Let me ask then, what things would you see needing to be done to make sure the program remains solvent? Ms. Thornton.
Well, I just think one should consider whether it's sustainable as a long-term way to fund enforcement and find enforcement. That's more along the lines of what I'm thinking.
If not for this program, how would we discover more of the bad actors inside? I mean, I think that's the fundamental part where both of us would agree. This is highly important. We don't want to incentivize folks to have to go out there and police themselves, but we do want to recognize there's got to be a clean pathway for folks to be able to raise their hand and say, the federal government or my agency is not working. I need somebody to come and investigate this.
Yeah, that's certainly a fair question, but I also think that the CFTC needs more funding to carry out its existing duties, one of which is enforcement. So.
Well, I think that bad actors have a responsibility in helping shoulder that far more than the taxpayer, but I hear what you're saying there. The average price of one tractor in my home state of Iowa at nearly $500,000, this is a major investment for anyone, whether you're a small farmer or whether you're a beginning farmer, and it directly hurts our ability to grow. Let me ask this, how can we ensure that the CFTC operates in a way that supports the markets while avoiding unnecessary burdensome red tape coming out of Washington?
That's a good question. I mean, we're coming today that we don't really have an ask, right, on CFTC authorization. We feel it's working correctly. I agree with you. As a farmer in South Dakota, I know the economics of that as well. So I think current status quo is okay for regulations on agribusinesses and those trading with farmers to make sure the system works well. I feel we're getting into tougher times. I think the next year or two is going to be even tougher than the past couple of years at the farm gate. So yeah, I agree with you.
As we highlighted with our chairman, my home state, bushel of corn, $3.89. A break-even point is $4.85. Mm-hmm. 3 years ago, we were at over $8 a bushel. America's farmers, farming communities, and the entire country is going to experience a spike in costs if regulation is one of the reasons that it causes an American farmer to have to spend more time filling out paperwork than actually being in the field.
The hearing of the Subcommittee on Commodity Markets, Digital Assets, and Rural Development is adjourned.